All right, and I'm going to go to the second scenario that we have. In the case of Ramirez versus Jackson, Judge Walters was conducting exploratory settlement discussions during a pretrial conference in the courtroom with the parties present. The judge announced a recess, and as he was leaving, he turned and pointed to the plaintiff's attorney, Mr. Monero, and said in an angry voice, "Your demand for money is BS. If you keep making this demand, you can stick it right here," while gesturing toward his buttocks with rolled up paper. Tom Wilkinson, if you were Mr. Monero, what would you do about the judge's comments at this point?
Well, first, I believe I would refrain from taking him up on his offer. Okay. If I'm convinced that my settlement position is reasonable, I might try to convince my client and my opponent to take the matter over to a good ADR neutral and continue the settlement discussions that way, or try to get maybe a magistrate involved because maybe it's best to get it away from this judge. You really need to focus on, as a practitioner, what's the best thing for your client, and really avoid, I think, going toe-to-toe with the judge in this kind of a scenario because things could just devolve and get worse. I might document it for my own file in case another incident came up. You know, judges occasionally do get upset, and perhaps rightly so, you know, when cases don't settle. And they take it out on whoever they feel is being unreasonable, and that may change from hour to hour depending upon how the negotiations go. But you know, the one instance here, in my view, hasn't so seriously prejudiced the client that I would be running to the president judge, or running back to chambers to complain, or filing a complaint, or moving to disqualify the judge. It would really have to be, you know, more egregious conduct, or repetitive conduct, or conduct that really seriously prejudiced my client going forward.
Madam President, when you were president of the American College of Trial Lawyers, did you explore how to address what you considered inappropriate judicial behavior such as this?
We did, although we did so gingerly for obvious reasons. Trial lawyers don't like to take positions that might offend judges as a group or even individually. But over a period of several years, having to culminate during the year I was president, we prepared and then issued a code of trial conduct, which has now been cited several hundred times by courts across the country. And it deals with the behavior primarily of the lawyers, but it also touches on the conduct of the judge. And I was interested to hear your comments because, of course, there's a second part to this scenario, but I found this unimaginable, unbelievable in 38 years of practice in my jurisdiction. Of course, it's Boston. It's a little uptight relative to some other places, but you would never, ever see or hear conduct of this nature from a judge, because if you did, someone in the courtroom, very possibly the permanent judicial staff, would file a complaint with the Commission on Judicial Conduct, which is tough. They are a tough group comprised of lawyers, judges, and lay citizens. And the kind of sanction that would come down on a judge for conduct like this would not be pretty. I mean, it may vary from jurisdiction to jurisdiction, but I thought this was way over the line, way over.
Well, Judge Walters returned to the courtroom, followed by the attorneys. Entering the bar area, Judge Walters turned, pointed to Mr. Monero, who was in the gallery, with others present in the courtroom, and said in an angry voice, "If you think you are going to get money out of this case, you've got shit for brains." Thank you, C-SPAN, for carrying this. "If you want war, you'll get war, and if you still think you're going to get money, I've got a Brooklyn Bridge I can sell you." Judge Ash, I know he wouldn't be your colleague, but if Judge Walters had been your colleague, what would you do, and what could be done to prevent this type of behavior in areas where the same standards that Ms. Lukey described don't apply?
Yeah, Mark, you'll be shocked to hear this, but judges are people too. You know, we have families and lives, and the funny thing about being a judge is when you first get elected, you go up there, all the lawyers are nice to you. They tell you what a great judge, you may be the best judge that's ever been in the country. They tell you that. All the court staff is nice to you. They say yes, sir, and no, sir, or yes, ma'am, and no, ma'am. So you kind of develop this thing, and then you go home. I remember it happened to me. I went home, and Rita, my wife, said, the dog is thrown up in the hallway. And I said, she said, will you clean up? And I go, honey, you don't understand. I'm Judge Ash. That's just not something I do. So right after I cleaned up the dog thing in the hallway there, I reflected that I'm really not as big a boy as I thought I was. But I agree. I think that first conduct is outrageous. This thing goes even beyond that. There are a couple of things to do. I had one person, like I said, I was involved in judicial ethics in my state for a long time. One judge said to a group of lawyers that if y'all keep on acting this way so childishly, I have some Mickey Mouse hats that I bought in Disneyland, and I'm going to make you wear them during your presentation. And what happened was one of the lawyers called me and said, this happened. Well, I got a couple of options. One is I could go ahead and report that person to the board, to our Board of Judicial Conduct immediately. That'd put them in there. Or I have the right to go to our presiding judge and talk to them, or I can go to the judge if I feel comfortable in doing that. I felt in my situation I did. I called the judge and I said, you know, I'm sure this isn't right, but this is what the story is. She goes, yeah, that's right, because you wouldn't believe how badly they were acting. I go, you can't do that. That diminishes people. You wouldn't do that in front of your mother. You know, you wouldn't want that on the front page of the newspaper. I think judges owe a giant responsibility to protect the trial bar from judges that have losing it or lost it. If this person did this, there's something else going on besides him just being angry at this person about a settlement conference. Mm-hmm. There's either a mental health issue, a drug or alcohol issue, a family issue. There is something going on. We as members of the judiciary own an obligation when our brothers and sisters on the bench are suffering to discover that and come to the rescue before they get lost. But we also need to protect good lawyers who have the right to advocate their case, and by doing that, then you've got to punish judges who are doing improper things. If you do that enough, usually just once, that will send a signal out to the judiciary saying this is unacceptable. And so, had to do that before, and it's difficult. It's difficult going to a fellow judge and say, you know, I think you got a drinking problem. And they go, well, I don't have a drinking problem. I said, well, I think you do, and you're going to go to TLAP, and that's our lawyer assistance program, and talk to them. If they clean you, they say you're fine, you're good with me. If not, I'm going to have to report you, and I don't want to do that. So you don't make a lot of friends that way, but you serve the profession that we signed up for.
All right. Well, Judge Jones, you were former president, judge of the First Judicial Court, First District of Philadelphia. What would you do about, or have done about a judge's behavior such as this?
Well, first of all, the judge's conduct was absolutely deplorable in both instances. As the president and judge here in the First Judicial District some years ago, when I was in that court, I did have one situation that stood out more than others in the arena of judicial misconduct, and it was more because the lawyers complained about the judge's conduct toward both the lawyers and people sitting in the audience. I brought the judge in for a meeting with the president, and I also directed that the supervising judge come to the meeting as well. And while there were no procedural protections, I thought it was most important to have another person there to hear exactly what I heard, to make sure that we heard it correctly. And then I heard it from the judge's perspective about what had occurred. I knew what I had heard from various lawyers about it. And then I proceeded to discuss, as Judge Ash suggested, are there other issues that are going on here? Personal, professional, other issues. And the end result was a discussion regarding counseling, regarding coming to the National Judicial College for courses, for judicial ethics and things of that nature, and also letting that judge know that my responsibility was such that I had to turn the information over because of how important it was to me and to the image of the system, to the Judicial Conduct Board. There are other systems in place, the Pennsylvania Supreme Court, the Judicial Conduct Board. Everyone has an eye toward making sure that the system's integrity is maintained. My responsibility as president and judge was to be the first tier in all of that. and the end result, that person is no longer a judge in the Commonwealth.
Dean Broderick, could you bring some completion?
I don't know.
Okay, would you try?
I don't know. I guess I just add my own comment, really. It's not clear from this whether another judge heard it, but whether another judge heard it or didn't, my view would be that progress happens through awkward moments. And if I were the lawyer in that case, if I felt that a record needed to be made, I'd request the court to make a record of the exchange. I would report it to the presiding justice, and I would file a judicial conduct complaint and ask the judge to recuse himself from my case. There may be a host of issues, as Judge Ass and Judge Jones were talking about. We had them in my state. But it's not for me to decide at the front end whether someone's got a drinking problem or a mental health issue. The conduct is offensive and crosses the line. It's for others with more information to decide it. And if I were a citizen sitting in that courtroom witnessing that, I would have no respect for the system when I drove home. And I think sometimes lawyers need to do awkward things, uncomfortable things. It's easier for a judge to reprimand a judge, but the system requires sometimes that we step up too. So I would think, were I that lawyer, I would have acted more aggressively, I think.
Okay, good. Yes, Amy, Professor Washburn.
At every level, it strikes me that the civility problems, one sort of missing ingredient in the solution is somebody who's a friend or a colleague saying your behavior crossed the line there. We're very reluctant to do that, and I've said before, I have friends who are judges, and law faculty are the same way. We're very autonomous and very reluctant to call one another down, but when you do it, it has a powerful impact. This is, I mean, I think about lawyers. The other side telling you that you're behaving badly is one thing, but if one of your colleagues or your friends or a partner at your firm pulls you aside and says, I don't know what's happening to you lately, but you're stepping over the line more, to me, that has the power to really force people to look at their behavior, but we're quite reluctant to do it. There's something about that about the autonomy we afford one another in this profession at every level that makes us reluctant, and I think we should lose some of that.